Yes.
With the consent of the opposite party, I beg to mention item number 25 of today's list. It's a hearing matter, Lordship. Can it be after 4 weeks, Lordship, due to some difficulty of my senior BM Chodhan?
25.
Yes, Lordship. It is a case of NIA,
Last week of May, my lord.
last week of May.
Prayer of learned counsel petitioner. With the consent of the other side, list the matter again on 4 weeks, no?
8 May and
May end तो दे रही हूँ. After last week of May लगे ना? Last
May
week of
end.
दे रही हूँ.
Oh,
21.
21.
deeply obliged.
Oblige, Your Lordship.
Regarding item number 14, my lord, perhaps case diary is not available, my lord. In anticipatory bail and there is no interim, my lord.
You're on interim. So when can you have? She did not receive, list the matter again on
29th of April. May I please also. Item number 8 and 9, my lord. Perhaps case diary not received, my lord. I am on interim, my lord.
8 and 9, she did not receive, list again on so and so interim passed earlier to continue till next week of list.
11/5. My lord, interim to continue, my lord, in both the cases. I am deeply obliged. May I please, I recommend item number 16, my lord. I just check the office of my lord. I take step for the respondent number 2, my lord, through speed post, my lord. On 31/3, speed post has been sent, but office service report is perhaps I waited. There is no such note, my lord. For respondent number 2, it's a POXO matter, my lord. My lord, that may be fixed with service report, my lord. Item number 16.
During mention, we cannot say so many things, we'll just say. List on the prayer of so and so, list again on. Right.
6, otherwise, my lord, search is submitted.
No, it's a criminal appeal. 16,
16 and 6.
Otherwise, my lord, TCR is available, but the service to the respondent number 2, my lord, informant.
Okay, we'll have it again, have it on another date
My lord,
by that time.
and first
Yes.
week of May, my lord.
Please, Lordship. Lordship, item 5, Lordship, after 2 weeks, Lordship. 2 weeks.
Item number 5 on prayer of learned counsel for the petitioner, list again. After 2 weeks, that day. That day. I got to do. 19.
May I please, Lordship? Item number 7, Lordship. She did not receive, Lordship.
Also, search it in method.
7 is started,
Pure call promise.
not received. No, scan copy is received.
Scan copy receipt. He's paying for time, my lord. Otherwise, search it in method, scan copy receipt.
Scan copy. You want another date?
Yes, Lordship. 24, Lordship.
Huh?
24.
The prayer of learned counsel, list the matter again on 24th.
It is
24th.
20.
May please, Your Lordship. In this case, after we file this bail application, we have been informed that charge sheet has been submitted. So we'll file an additional affidavit to bring on record the charge sheet, my lord. Can we?
Let us call for the TCR also then.
We don't have the ARC number, that is why. Otherwise, the PS case number is reflected, my lord, that perhaps that will also do.
It is submitted by learned counsel for the petitioner. The charge sheet has already been submitted. And waits for time to file an additional affidavit incorporating the charge sheet. So hence, release the matter again. on
27th of April, my lord. Attested. I'm deeply aware. Please, Your Honor. This is the fourth bail application, Your Worship. With the new ground is that the other accused person are being released on bail. And on the, this, after 4 months, we have filed this, bail application where CD is not being called for. And Lordship, moreover, no, notice has not been issued to the other accused person till date. And moreover, Your Lordship, the petitioners has been rejected in the earlier bail application 6/1/26. It was contended that the petitioners are in contact with the the main accused person, that is the driver. Whereas the driver, we, the petitioner, do not have any mobile phone to be in the contact with the driver. So these are allegation that is made against us is completely vague, Your Lordship. And moreover, Lordship, the driver of the state, driver of the state truck is not being apprehended, or being apprehended is not being, will be revealed by the up-to-date case diary, Your Lordship. And if so, he's been apprehended, the statement that has been given by him to the police will be very much necessary for these accused persons.
On the last occasion, it was dismissed on the first day
Yes, Lordship.
without calling for.
My lord. This bail application is not maintainable, my lord, because, my lord, earlier 3 occasions lordship has rejected his bail application. Now this is the 4th time, my lord. There is no new ground, my lord. And new ground has to be, my lord, after rejection of the earlier order, my lord. So, my lord, this bail application, my humble submission, my lord, this bail application is not maintainable, my lord, and it should be dismissed with cause, my lord.
Lordship, the bail
Because they
application.
cannot take this court for granted, my lord,
No.
filing one application after another.
There are
my lord.
4 new grounds, Your Lordship. And there are 2 grounds that we have taken is being rejected or not. It has not been mentioned in the earlier order, whether the plea has been rejected. It has been not been mentioned, it's not been contended, Your Lordship. The first new ground hearing is that, Your Lordship, till today, no notice has been issued to the accused person. Even then, the other accused person has been granted bail. They have given their statement before the IO. And till today, after 4 months of lapse of the last CD was being called for, no notice has been issued as per the Ernest Kumar case. And moreover, the new ground, another new ground is that, Your Lordship, here, whether the driver of the said vehicle is being apprehended or not. Now, another new ground is that, Your Lordship.
All those grounds were available before, and then what is the question of issuing notice? This is an AB.
Yes.
They may not seek to issue notice. Is
Yeah,
that a
it's
ground
not
for
seek to
granting
notice.
anticipatory bail?
There is no mention of the Ernest Kumar case that it cannot, it is not invalid, it is not applicable in the case of anticipatory bail, Your Lordship. And moreover, Your Lordship, while rejecting the earlier bill of application on 6/1/2026 of these accused persons, Your Lordship, it was being contended that the driver of the truck.
We are saying it is not applicable.
Lordship.
We are saying it is not applicable.
If the notice part, we leave it, Your Lordship, the other new ground.
What
we are
does
taking-
Ernest Kumar say? If it is below 7 years, within up to 7 years, then you have to issue a notice.
Yes.
If you intend to arrest,
No, Lordship, even we are not taking into consideration of the notice part also.
if he is
The-
arrested without issuing that notice, then it is bad. Here it is not a question of arrest.
If
He has
we-
not been arrested.
If you leave
So
the.
where
notice
does
part-
Ernest Kumar come in now?
If you leave the notice part also, Lordship, in the last rejected order of 6/1/2026, it was being contended that the petitioner is in contact with the driver of the said truck. But whereas we do not have any mobile phone, Your Lordship,
We don't know.
to
That is
be in
a,
contact with the.
that was already decided after perusal of the CD.
No, Lordship, this has not been contended in that particular.
Yes, it has.
No, Lordship, this was not being contended in that petition, Your Lordship.
If you did not take that ground, that is up to you. That is
was
not a
the-
new ground.
After this rejection has been made, Your Lordship, this is the first time we are taking this ground, Your Lordship.
But that ground existed earlier also.
But this has not been rejected, Your Lordship.
That is your fault. You did not take it up. Ground must arise after the rejection.
Lordship may reject my bail application after calling the up-to-date case diary, your lordship. It has been more than 4 months that the CD has not been called for in this case.
Yes. Head learned counsel for the petitioner and learned additional PP. This is the fourth time that this pre-arrest bail application has been filed on behalf of the same petitioners. All three earlier bail applications were rejected, and by order dated 23/3/26, the last pre-arrest bail application was rejected without calling for the CD, as no new ground had been made out. As far as the present petition is concerned, I find no reason to call for the CD. Accordingly, the petition stands dismissed.
All right.
Please, my lord. My lord, I am praying for the transit anticipated bail lordship. That lordship, this present petition is a lady lordship, the young lady, and she has received a notice under section 179 of BNS, page number lordship. The type copy page 16 lordship. Another state lordship, that is the West Bengal lordship. This notice has been issued lordship, the Baranagar PS case number so and so, and an offense under section 318 and 3 subsection 5 of the BNS lordship. Cheating and dishonestly, the 318 subsection 4 of the BNS defines the cheating and dishonestly inducing on delivery of the property. I am paying for lordship. The interim protection may be granted lordship. Will appear lordship before fullest investigation officer lordship. For limited period of time.
Yes, PP, any submissions?
My lord, the notice, my lord, that my learned friend has annexed, my lord, in page number 17, my lord, the original, my lord. Page number 17, my lord.
Yes.
Notice, my lord, under section 179 of the BNSS, my lord. And it says, my lord, the police officer's power to require attendance of witness, my lord.
Yes, lordship, as a witness.
Now, my lord, admittedly, my lord, they have not annexed the FIR, my lord. So we do not know whether the, my lord, allegation, there may be some allegation or may not be any allegation, my lord. Now, my lord, pursuant to this notice, my lord, as an witness, my lord, not as an accused, my lord. Because if she would have been accused, my lord, then 33, the notice would have been issued, my lord. So whether, my lord, any, my lord,
bail application, lordship.
protection is required or not, my lord, that I leave it to your lordship, my lord.
That's why I'm coming before this honorable court, lordship.
So there has to be some apprehension, my lord, that in the, my
Yes,
lord, while
anticipated bail may be some.
going to appear in the, my lord, West Bengal, my lord, I may be arrested during, my lord, in between the, my lord, transit, my lord. Then only question of transit bail will come. My lord.
Yes, lordship.
ওচৰত আনি থৈ দিম। ওচৰত ঢুকিব লাগিব। হ'ব। It says at your suitable place also. You don't have to go.
আমাৰটো একোৱে হ'ব West Bengal to suitable place to smart room.
You can inform them that this is my suitable place. Come and meet.
Suitable place may be lordship it কোনখানে আসলে Potasi Lumbering. In fact,
Ah,
Potasi Lumbering may be
I don't know that you know what is your suitable.
there is
place.
I'm ready to go lordship.
Question is that, my lord, there cannot be any blanket order, my lord. If transit bail, anticipated bail is maintainable, my lord. Only, my lord, when there is the apprehension, my lord. There, from the notice, my lord, it's just in the 179 notice, BNSS notice, my lord. Well, that is also to a witness, my lord.
That is correct lordship. As anticipated bail may be apprehension of arrest lordship.
Then
Then lordship I have
what is your apprehension?
179 as per lordship, maybe as a witness lordship. Calling this notice lordship.
Hmm.
Maybe lordship. Apprehension maybe. That's why this notice have to issue lordship, this investigation officer lordship. I am praying for transit bail lordship for limited period lordship. Will appear lordship.
You have not even annexed the FIR.
It is absolute correct lordship, but as per the notice only I have received the notice lordship. That's why I am not praying for anticipated bail lordship. I am praying for lordship anticipated transit bail lordship. That case was registered outside of the state lordship. This is West Bengal lordship. I have filed lordship, will file lordship under state lordship. at least for the protection limited period within 10 days, lordship, will appear, lordship, before investigation officer, lordship.
The problem is that transit bail is also a form of anticipatory bail, and you are asking us to grant it without knowing what the case is about.
And there has to be some apprehension, my lord.
Which other judgment that is possible? নাই, কিন্তু বাবাই ক'তো আছে, কি দিব? Okay, okay. But see, this judgment, lordship, this other high court lordship, not our high court, the Allahabad high court, seems same lordship, this the transit anticipated bail lordship, this allow lordship. As per,
In this case, FIR and everything was there. Court
that
has
is-
discussed
that
the
is-
facts of the
that is-
case.
that is correct, lordship, but there is a,
We are
No
only on
FIR.
that point.
yes.
Otherwise, we have also granted transit anticipatory bail on a number of occasions.
But as
We are
per,
finding difficulty in this case because of that.
but as per, there is a received notice only, lordship. This transit bail, lordship. Otherwise, no FIR, lordship.
Yeah, FIR must be there.
But this
There is a
maintainable,
police case.
that is correct, this maintainable is other state lordship. This case outside of the state lordship, this anticipated bail may be lordship. But I am
Alright.
paying for transit lordship, only for
Alright, we'll
interior
see.
protection is transit bail lordship.
All right, we'll see. Next.
Deeply honest lordship.
MRD. Item number 4.
But on the last occasion, respondent number 2 had sought time to file a written objection. Lord may see order of 12th of March. I have received a copy of the written objection from the respondent number 2. Firstly, my lord may record that I don't know whether it has been actually filed. Secondly, and most importantly, just one second. Secondly, and most importantly, this report which had been requisitioned by the Honorable Court from many, many dates before, that report seems to have escaped the light of the day. I am only requesting that this petition has been filed 1 year back. My client has not been mentioned in the FIR. She is not an accused. And this report, one date may be fixed for final hearing. And this status report, as was directed by the Honorable Court on 21st of March, one last opportunity may be given such that the matter be heard finally.
That status report order was passed way back on 20/01/26, but on
Not even
subsequent
before
dates,
that.
it seems no reminder was issued, although the report was not received. All right, heard learned counsel for the petitioner and learned additional PP. Also heard learned counsel for the respondent number 2, who has submitted that the objection has already been filed on 20. But the same is not available. Is it available? Not available. not available on record. Registry to place the same on record. Further, issue reminder to the OCCIDPS, to submit the status report. What is the case number now? Earlier it was Varolomukh PS.
Here, yesterday also, my lord, yesterday the IO has again submitted the case diary, updated case diary, my lord. But there is no one, my lord, he has only regarding that, in the case diary, there is no specifically, my lord, there is no status report, my lord, in the case diary regarding the present. Although he has submitted the CD only yesterday, my
It is up to date.
lord, up to date CD, my
Then do we need a status report?
lord, your lordship.
Huh? We don't need a status report then.
Let me hear the matter.
Then cut off the status report part to cancel that. The up-to-date CD is also available. Hence, list the matter for hearing on well, May CD is with you. So earlier date maybe necessary. You'll retain the CD, huh?
12 May.
My lord, I have a small request. I fly down from Delhi for this. Any other date apart from 12th?
You give the suggestion.
Lord, 10th, 11th, 14th, 14th is it? Lord, may I continue the interim order which was.
Interim order first to continue till the next date of listing.
I am deeply grateful.
Item number 6, bail hearing BA.
Regular bail application lordship. Allegation is POCSO 6 lordship. Earlier case there was call for lordship, but as per information charges submitted lordship. Lordship may call for TCR lordship.
So it is submitted that charge sheet has been submitted by CS number so and so dated so and so, hence call for the scan copy of the TCR list again.
Charge sheet number 13/2026, dated 17/2/2026. 13/26, that is the number, and dated 17/2/2026. Next date, any date, scan copy.
28.
Obviously.
23 man delay.
Item number 10,
It remain promote nahi wo. 28th April, whether it is 20th April, whether it will come from the Vishwanath really, it will not come. May, at any time.
time based.
Okay.
Please, Lord. In this case diary was called for last occasion, my lord. There is a postmark where lordship was directed for issuing registered post to the informant party, my lord. That's for number 2. And FIR, my lord, actually what happened is, it was actually an occurrence of 2021. In order to make it a POCSO, my lord, it was 5 in 2026, my lord.
As per my instruction in this case, search sheet submitted.
Lordship, I am for the informant. We have filed our vakalatnama and we will file our objection as well.
If charge sheet has been submitted, we'll call for the TCR.
Yes, sir.
Is learned counsel for the petitioner Learned counsel enters appearance on behalf of respondent number 2. Learned additional PP submits that charge sheet has already been submitted. Right?
Case number 38/26 dated 31/3/26.
Hence, call for the scanned copy of the TCR. In the meantime, respondent number 2 may file objection. Lift again on.
7 May.
7th May.
February 28. 28.
28, no?
Please, your lordship. Case diary.
Case diary is there, but amicus need to, amicus was
appointed last
appointed. POCSO case, lordship.
Name is not shown.
On last occasion, informant was present personally, then the amicus was appointed. And the office was directed to serve a fresh copy upon the amicus.
But the name of the amicus is not reflected in the cause list, lordship.
Oh, causeless.
In the cause list, lordship.
Is there in the order. Lordship, MK Brown was appointed.
But we'll have it day after tomorrow then.
Lordship, can it be on not day after tomorrow, Lordship, on 27, Lordship, Monday?
Alright. But learned counsel for the petitioner and learned additional P. The name of the amicus ms.mk Brown has not been shown in the cause list. Hence, list the matter again on 27.
CD is available, so it need to be
Maybe
retained then, lordship.
Matter again on 27. For showing the name of MK Brown as appearing for respondent number 2.
On 27. Deeply obliged.
29.
May it please your lordship. Well, here, my lord, petitioner was arrested on 28/2/26, my lord. This matter came up before your lordship, my lord, before vacation, my lord. And lordship has said, my lord, that 40 days, it will be better if it is processed 50 days. So today is 53 days, my lord. And the contraband which is alleged to have been seized is 4 kg 649 grams, my lord. Page 10 from page 10, lordship will get it, my lord. Lordship knows that 20 kg is the commercial quantity, my lord.
No charge sheet has not been filed.
However, FSL is not there, lordship. And moreover, 2-3 points, I will point only 2-3 points, lordship. Firstly, in the seizure list, in his house, these things has been found, though it is intermediate, lordship. And there are witnesses also present, lordship, who has stated his name and the whole procedure, what has been done, and they have identified this person, lordship, and stated that this 4.818 grams of lordship, this ganja is found.
That is with container, my lord. Without container, it is 4.649 grams.
But in inventory, it is also written in the same lordship,
But-
4.818. In the inventory lordship.
That is with the container, my lord. From page 10, my lord, lordship may get it, my lord. Only on the detention, my lord.
What's the difference?
No, Lord.
818 and 649.
Lordship. Only on the detention, my lord. 53 days in custody, my lord. Don't have.
What is the name of the present accused? Bilal.
Bilal, my lord. Bilal Hussain.
In his house, this ganja found lordship.
It is pending for FSL only. So basically you have no control when it will come. And you cannot file the charge sheet before that.
Could have.
But so put the petition on. No, PP. This is an application under so and so. Facts of the case briefly stated is that on 27/2. (26/2). 2026. A search on the basis of prior information, a search was made in the house of the accused by a police team, and in course of such search, suspected ganja, net weight of which is 4.649 kg, was recovered therefrom in the presence of witnesses. An FIR was lodged on 27/2/26 in this regard. And accordingly, the aforesaid PS case came to be registered. It appears that the investigation of the case is almost complete, appears from the CD, and is pending for receipt of FSL report. In the meantime, the petitioner, who was produced before the magistrate on 28/2/26, has by now spent 52 days behind bars, and the case relates to intermediate quantity, having regard to the period of detention. The prayer for bail is allowed. The petition shall be released on bail of rupees 50,000 with 2 sureties each of like amount, to the satisfaction of the.
Special judge Borpeta.
This bail has been granted subject to the condition that the petitioner shall not try to influence the witnesses or tamper with the evidence, and that he shall cooperate with the trial if one commences. Petition stands allowed accordingly.
I'm obliged, my lord.
030. Gauhati.
TCR is not received, I think. None appears for the petitioner. TCR also has not been received either. Hence, list the matter again.
28 April.
জলদি নাহিব কালি ইমান জলদি টিচিয়াৰ নাহিব যোৱাকালি পঠাইছে দুসপ্তাহৰ
7 May. Bail hearing. 11.
My lord, in this case, my lord, regarding service report on
My lord,
respondent number.
service report awaited, my lord. I talked to the IO, my lord. IO has paid for 2 days' time because, my lord, respondent number 2 is under Sapor, my lord, police station. Yeah, once he tried to serve the, my lord, notice, my lord. Today, my lord, I contacted him, then he.
Today?
Today I contacted him, then he prayed for 2 days time.
2 days time.
2 days time.
My lord, may I pray one thing, my lord? The case diary has since long been received. So up to date case diary may be called for, my lord. There is no interim order also in.
All right. Service report on respondent number 2 is not complete. It is stated by learned edition LPP that the IO has sought further 2 days time to cause service of notice upon the respondent number 2. The to date CD would no, just cut that line. Hence list the matter again on so and so. Send back the CD for resubmission along with up to date CD.
We're already up to 13/3/26.
Up to 13/3.
13/3/26.
Then it is fairly up to date, I think.
My lord, 1 month already.
Her 183 BNS statement, everything is available, my lord. Otherwise you statement. of
Then if
weakness.
you send back, it may not come again on that day.
Only with respect to latter part, my lord. Up to
Huh?
date. Because some investigation has taken place, my lord, in the meantime also. I have instruction. my lord.
All right. Send back the CD for resubmission in up to date form.
Not sure.
My lord,
List again also.
parking for me.
13 May. Much.
This is also POXO matter, my lord.
My lord, in this case also service report awaited, my lord.
Lord, as per office note dated 8/4/2026, service completed, my lord. As notice served to the respondent number 2.
Hold on.
Black mark yes.
Then let us may be appointed.
Notice has been served because, but that date which was mentioned in the notice, that is gone. It was served late. Once notice has been served,
Cus may be appointed. Amicus may be appointed.
even though the date is, they could have engaged if necessary. Learned counsel for the petitioner. and learned additional PP. It appears from office note that notice on respondent number 2 has been served, but none represents the said respondent today, hence. And so anybody available, amicus? Your name? Sir is appointed as amicus to represent the respondent number 2. Copy of the petition be served upon her. List the matter again on. Give it. On my lord.
Wait, 27 April? Can it be on 27? Next Monday. CD is available also.
If CD is available, I got detail. Did you?
Deep level.
Item number 13.
My lord, notice served in this case.
Service report is awaited, Lordship.
Service report received, my lord. Notice served.
Where from do you get that?
I have received from the my lord, police station.
Learned additional PP submits on instructions received. That notice on respondent number 2 has been served and copy of the said, return copy of the said notice has been furnished to the court. Keep the same on record. None has appeared to represent the informant. Hence, same, we can appoint last day, counsel principal also is appointed as amicus to represent the respondent number 2. Copy of be served upon her. This is the matter on. Yes, give it date.
28/4.
CD is available.
28 on the 7th.
27th. Supplementary 31.
May it please your lordship, the council is engaged in court number 9. Kindly allow time being.
Scan copy.
CD not received.
On your side, CD location.
Receive. After some time.
After some. Lordship.
Order item 15. Fifteen.
None appears. List again on. There the reading. That.
Number 17.
May I plead the lordship? I have for condonation of delay of 125 days. Lordship.
Have received the copies of IA, but we have not received the main petition copy of revision petition copy. We have not received. And last occasion, order honorable court has fixed on 4/5 for filing, fixed the case on 4/5. So we need some pray for some time for filing the objection, Your Honor. 1 week time. We're praying for 1 week time, Your Honor.
4/5 were listed. There is to be listed on 4/5.
Okay.
As per earlier order dated 01/04/2026. As per earlier order dated 0. The case is to be listed on 4/5/2026. Hence, list the matter accordingly.
I know.
18. Number 18.
18-1 status report was called for earlier
Wait,
from
yeah.
Silchar PS regarding one GD number 54. Well, that report not yet received.
There is direction of this honorable court earlier, because Gandhinagar police station submitted a report and to take instruction on that regard, madam. Madam, after investigation, they found nothing against me, madam, and accordingly directed to unfreeze the bank account of the petitioner. And I have filed an additional affidavit, madam.
Bank account to heavy query.
Oh, to decrease me.
Right way to pay us in success. Matters.
Affidavit report is satisfactory.
Additionally, bank account to decrease कोई दिले इतना मेरा तो infraction
तो पुलिस ध्यान है तो बैंक को पढ़ा
Yet to अपना SBI account to
the petitioner might approach the concerned bank, my lord, but they have not unfreezed the account of the. And this account is the, my lord, salary account of the petitioner. And already retired him, my lord.
You were supposed to prosecution, you were supposed to verify the communication from the Gujarat police.
Yes, my lord.
yes. Well, regarding that respect, I have not received any instruction from the IO.
They filed an additional affidavit
Yes, my lord.
bringing on record a letter dated 31/12/25 written by the Gujarat police.
Yes, my lord.
That investigation completed, no objectionable matter found regarding the account.
That copy of the additional affidavit is not with me, my lord. I may be allowed to survey well, copy of the additional affidavit.
And this order was, this so.
Without service, it would not come, but. You may not need the additional affidavit, just the copy of that letter.
Last, after direction of this honorable court, we submitted, my lord. My learned friend is not there.
That additional affidavit is not in our file.
Or order also we communicated to for learned people.
No,
Maybe that already
Was
is the
there, my
account.
lord.
Anyway. You serve a copy of that letter. Annexure A, page 41
Plus,
to him.
we submitted before K. Busso, learned PP earlier.
Well, let's say may fix it day after tomorrow. I will get the instruction.
Yes, but that will be better.
All right, on the prayer of Mr. P. Bothagood, learned additional PP, leaves the matter again on the 23rd, 2013. এই মাহতে। You give a copy of that letter so that he can get the.
Today itself, sir.
Item number 19 and 20.
In item 19, your lordship, there is an issue regarding service upon respondent number 4. We have been asked to take fresh steps. We have taken it, but AD card has probably not been returned yet. Register served and appeared to yours.
This is 8-4. AD card in respect of respondent number 4 has not yet been received back, hence await service. List again on
30. 34.
34.
34 reservice.
It will be too short, probably. It will not be possible.
Well, I'm appearing in item 20, my lord.
In the second week of May or so.
I think this connected matter I have already given, not by me, okay, before another bench. Okay, list again before another bench.
Any other bench?
To move to court.
Any other bench?
Oh.
1920 and that
Well, if your lordship.
date.
Any date, my lord. After that, May first week.
Side of it.
Same order in 20 also, not by your lordship.
14 May.
Lords.
Interim shall continue.
Getting order past third date to continue.
Deeply obliged.
And congratulations, Mr. Kamar.
I did my best, but even then, my lord. One point was involved whether hostile witnesses doesn't get washed off, that I could not impress. Anyway, thanks.
21.
May it please your lordship. 25th of February, the order was passed that the interim order will be considered after receipt of a TSR. Today the TSR has come. Copy. So what had happened in this case, and on the ground of malicious prosecution, I have thought the quashing of this proceeding. Now, I am a journalist, your lordship. While discharging my duty, I was attacked by a woman. I had gone to cover the news of her husband. I was attacked and physically assaulted. I lost the FIR. She was arrested by the police. And her father-in-law lost the FIR on the same date after 2 hours, alleging that I had assaulted. Now, pursuant to that, 354 case has been registered against me. And because of her 164 statement, in 161 there is nothing. 164 statement, a charge sheet was
What
filed.
about service?
Service, your lordship, it is complete. Because we have tracked the report, 2 and 3. Also in the trial court, on the last occasion, we had given a petition informing about the pendency of this case. They were also present in the court.
Today, my lord, matter is listed for order and TCR received.
Orders.
Considered. Will you come up for admission?
So only, I pray that till the pendency, my proceeding may be stayed before the trial court. On the last occasion, I had faced one judgment, Mahmood Ali. Today, I am relying on another lordship, Vinit Kumar. The Take your lordship through the documents once. You will find my journalist ID at page 24, my petition. This is Arifur Zaman, the petitioner, correspondent Assam Talks. Lordship, then the FIR that I had lodged is at page 25.
Where is the FIR of the present case?
FIR of the present case is at annexure 4, page 31. But before that, I had lost a case. Your Lordship, may I read the EPN FIR? To the officer in charge, Moirabari Police Station, 11/8/2023. Informant Sadar Ali, accused Arifur Zaman. Sir, with due respect, the informant begs to say that my son, Muhammad Khairul Islam, owns a shop at Moirabari Bazar on 11/8/2023 at about 7:30 PM in the evening, while my son and daughter-in-law, Masammat Marina Begum, were running their shop at Moirabari Bazar. The said accused person, being swayed by previously held grudge, entered the shop of my son unlawfully and swore by using obscene language and severely injured my daughter-in-law by slapping and punching her with his hand. The said accused person tore the clothes of my daughter-in-law by pulling the same and threw it to the ground and threatened to kill her. In the medical report, there is nothing, Your Lordship. Thereafter, Lordship will kindly peruse my FIR also, Your Lordship. This was lodged 2 hours prior to this at page 25. Page 25. This is informant Arifur Zaman, accused person Marina Begum, and number 2 Asad, that is brother of Marina Begum. Sir, with due respect, the informant begs to state that I am a reporter of NKTV on 11/8/2023 at about 7:30 PM. In the evening, the police from Moirabari PS went to arrest the husband of the aforesaid accused number 1, Muhammad Khairul Islam, at Moirabari Bazar. And I went to perform my duty as a reporter of NKTV. The aforesaid accused persons obstructed me from performing my duties and slapped and punched me by hand and assaulted me with sandal, thereby severely injuring me. The said accused duo pushed and shoved me, and the accused number 1 snatched my microphone. The accused number 2 snatched my Realme mobile phone and damaged the same by throwing it to the ground. And the accused number 1 snatched the silver chain that I was wearing on my neck. The said accused duo threatened to kill me. Therefore, I request you to take legal action. And pursuant to that, Your Lordship, at page 29, the seizure list is there. My Realme phone was seized by the police and the display was broken. Now, if Your Lordship comes straight away to the 161 statement of the victim at page 89. Before that, Your Lordship, only one aspect I wanted to point it out. My FIR was lodged at page 27, Your Lordship will find. My FIR was registered 11/8/2023 at 9:30 PM, being GD entry number 291. Now, the other FIR, Your Lordship will find at page 33. It was lodged on the same day, time 11:30 PM, GD entry number 296. So after 5 entries later, it was made, Your Lordship. After 2 hours, purportedly after 2 hours on the same day. And the case was registered. Now, if Your Lordship will kindly come to page 59, the 161 statement of the victim, namely Marina Begum, is at 31 years. My name and address above mentioned is correct. On being asked by you, I state that on dated 11/8/2023 at about 7:30 PM, a team of police was conducting search at my husband's shop. And on the entire story, what I have stated, she is saying in her 161 statement that a team of police was conducting search at my husband's shop, Khairul Islam, at Moirabari Bazar. I put up a national flag shop near my husband's shop. Someone was filming a video footage at my shop in which I was selling. So she is referring to me as someone. Now, the father-in-law in her affair said that I have previously held grudge against her. I put up a national flag shop near my husband's shop. Someone was filming a video footage at my shop in which I was selling. I told him to stop filming video at my shop and go to my husband's shop where the police was conducting search. I tried to stop him. During that time, he pushed me back and I got injured. Then I stood up and tried to stop him again. That's all to say. It's only this much she has stated, Your Lordship, that I had pushed her and she got injured. Then she again stood up and tried to stop me in 161. Now in 164, Your Lordship, she has embellished a bit. 164 I will place on the same day it was recorded. 161 is recorded on 21/8/2023 because she was in custody for 10 days, Your Lordship. On 11/8 she was arrested and for almost 9-10 days she was in judicial custody. So on 21/8 this statement was recorded. Again on 21/8 she was produced before the magistrate. Before the Honorable Magistrate, what she says, 164, Your Lordship will find at page 96.
In 164, she is supporting.
164, she is saying something different, Your Lordship. Now, in the medical report, she is not at all injured. The medical report is at page 100, Your Lordship. She is saying, I pushed her, and I punched her. All she have said that I assaulted her, but page 100, Your Lordship will kindly see. I have annexed. Within 2 hours, the medical was done. Her medical was done. Clearly, there is an opinion of the physician, no injury. And the cloth part is also, Your Lordship, there was no seizure of cloth. Nothing was done, Your Lordship. No incriminating material. And this is the judgment, Your Lordship, of the Honorable Apex Court, where it says that in a case of apparently which is malicious, even if there are some elements in 164, then the court can exercise its judicial conscience and quash the proceeding to protect the petitioner from abuse of the process of the court. Page 22, paragraph 22, 35 and 39 and relevant, Your Lordship. Paragraph 22 will read. Vinit Kumar, paragraph 22. Lordship, page 933, paragraph 22. The judgment of this court in state of Haryana and
Have charges been framed?
Lordship,
Charges framed?
charges framed, Your Lordship. Evidence not yet started. Charges framed. The judgment of this court in state of Haryana and others versus Bhajanlal and others, reported in so and so, has elaborately considered the scope and ambit of section 482 CRPC. Although in the above case, this court was considering the power of the High Court to quash the entire criminal proceeding, including the FIR. The case arises out of an FIR registered under section 161 and section so and so 5 of Prevention of Corruption Act. This court elaborately considered the scope of section 482, article 226 in the context of quashing the proceeding in criminal investigation. After noticing various earlier pronouncements of this court enumerated certain categories of case by way of illustration where power under 482 CRPC can be exercised to prevent abuse of the process of the court or secure ends of justice. Paragraph 102, which enumerates 7 categories of cases where power can be exercised under section 482 CRPC, are expected as follows. Now, I am relying on paragraph number 7, Your Lordship. At page 935, where a criminal proceeding is manifestly attended with mala fide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Now, Your Lordship, kindly come to paragraph 35 at page 941. 941. I'm only taking Your Lordship through the relevant portion. The fact is that no medical examination was got done on the date of incident or even on the next day when IO asked the complainant and her husband to get done the medical examination. This was a case of rape, allegation of rape, Your Lordship. Subsequently, it was done on 2011-2015, which was wholly irrelevant. apart from bold assertions by the complainant that all accused have raped, there was nothing which would have led the courts to form an opinion that present case is a fit case of prosecution which ought to be launched. We are conscious that statement given by the, this is important, Your Lordship. We are conscious that statement given by the prosecutix or complainant under section 164 CRPC is not to be lightly brushed away, but the statement was required to be considered
All right, I
along
think we'll,
Lordship. Along with
to have a hearing, we'll step further proceedings.
Regarding
Alternate
otherwise
counsel
only
for
I
the
would like to
petition.
point out, he is insisting on the injury part. Well, under section 354, my lord, injury is not at all required, my lord. Only, my lord,
No, we are on her statement, basically.
criminal assault or criminal force to woman with intent to outrage her modesty. So injury may not be there, but my lord, regarding other part, criminal force to woman, my lord, with
So
intent to
pushing,
outrage her
merely
modesty.
pushing may not amount to
Yes, yes,
criminal force.
yes.
There has to be some intent. Third learned counsel for the petitioner and learned additional PP. PCR is called for has been received. The consignment stroke MO tracking report submitted by learned counsel for the petitioner indicates delivery of notice to the respondent number 2
and 3.
on 13/3/26. However, none appears for the respondent number 2.
2 and 3, Your Lordship. Informant is different than victim.
2 and 3.
2 and 3.
The 2 question 2 and 3 already. There are also heard learned counsel on the prayer for interim relief. Having gone through the TCR and noticing the discrepancy in the statement of the alleged victim. Vis-a-vis the contents of the FIR. It is provided that further proceedings in so and so case PRC case number 933 of 2023 pending in the court of
JMFC, Morigaon. Judicial Magistrate First Class, Morigaon.
JMFC Morigaon shall remain stayed until further orders. Place the matter for hearing on. Thanks. You already admitted earlier.
Lordship.
Matter, just as matter is admitted for hearing, list again, list for matter for hearing on such. 12/5.
Much okay.
That consignment reporter keep the same on record.
Item number 22.
May I please, Your Lordship? My lord, CD was called for.
She did not receive list again on.
On, my lord, 19th of May,
This is the second occasion. She did not receive.
criminal petition, my lord, for quashing of FIR.
28.
No, 19th May, my lord.
Huh?
May.
19 May. All right, 19 May.
All right.
Carrying item 23.
$2015. What is this?
Yes, Lord. We have to pay for some other day, Lordship.
Why?
Today, Lordship. I have some problem.
Last date also you took adjournment.
Appellate judgment, my lord. Appellate judgment, my lord. Whether lordship can take up this matter or not, my lords, I am not sure. Appellate judgment, my lord, whether.
I'm not following you.
Lordship.
Appellate judgment, my lord. This is a revision petition, my lord, because
Lordship, by you,
concurrent
Lordship.
findings by the trial court as well as appellate court, my lord.
Page
Where is it?
53, Lordship.
Huh?
Page 53, Lordship.
For my judgment.
It was my Lordship.
This lordship is lordship judgment or not, my lord?
Yes, I think it is my judgment from Kachar. Place the matter before another bench without me. S.K. Sharma, J.
How like this?
Made, please, your lordship.
Item number 24.
The respondent number 2, the youngest counsel is out of station, my lord. I am appearing on behalf of FL Oscar. Otherwise. Yeah, the matter, it is basically a
Learned
question of
count,
law.
huh?
It is basically a question of law. The learned trial court has exercised the power under section 319 CRPC and had called for the accused to face the trial, who are not being otherwise charge sheeted. This is the case.
So you have to hear the senior. Learned counsel for the petitioner. Learned counsel for the respondent number 2. Mr. F.L. Oscar is stated to be out of station today and accordingly prayer has been made on his behalf for adjournment.
F.A.
Hence, list the matter again on. Just give a date.
28. 4.
28.
Obliged, Lordship.
Item 26.
May it please your lordship. My lord, this is an appeal against equital milord in the 130th proceeding milord. I am the complainant milord. And despite no rebuttal on the part of the accused milord, he admitted his signature on exhibit 1, this is a check. Thus the service completed. Is he received not appeared. And moreover, milord, learned trial court milord, while dismissing their case milord, this evidence part of the as of absolute overlook, as well as it is held that there is a no seal in the bank's record, whereas exhibit 1, prima facie, it is proved there is a seal of the concerned bank, my lord. Lordship, kindly have a look, the exhibit 1.
This is a check bounce.
Check bounce, my lord. Annexure 1, page 16.
This is item
26, my lord.
why no name of any private respondent is shown?
The justice service, last occasion, this honorable court recorded justice service complete he received, but not appeared, my lord.
Where is your affidavit?
Yes, my lord.
It is not on record.
11/3/2026 order. Sorry. Well, it is rough base, my lord. It is the order.
That is already before me.
And in this matter, the learned trial court admittedly recorded that the accused, the respondent, they failed to rebut the evidence of the prosecution. Despite this, all this recorded, my lord. And there is no, only granted there is no seal in the bank documents. So he has been not considered, my lord. And he is acquitted, my lord.
The office note says after verification in the CIS, it is found that no affidavit has been filed or received by this registry.
The justice service we have record. It is the I, my lord, this is the, it is in the record, my lord, justice service of affidavit, my lord. Kindly, my lord. আগত সার্ভিসটো যেতিয়া নোটিছ দিছিলো হেৰি কৰা নাই justice service receive কৰিছে prepare কৰা নাই
I don't think you have submitted it before the registry. On earlier occasion also, that was the observation. The registry was directed to place the same, that was 11/3/26. Then 8/4/26. Registry says no affidavit has been filed.
It is the affidavit, my lord. Check it.
That is your affidavit.
Yes, my lord.
Where is the court copy? You are not supposed to keep it in your pocket. You have to file it with the registry.
My lord, as per my
How can we proceed in the light of this note, office note?
then lordship, then I will verify it, my lord.
As per office note date, although hard learned counsel for the petitioner who submits that affidavit of justice service has been submitted. But as per office note dated 8/4/26, submitted on 28/1/26. Okay. But as per office note dated 8/4/26, after verification in the CIS, it is found that no affidavit has been filed or received by the registry till date.
My lord,
Petitioner to take necessary steps accordingly. Please the matter again on.
my lord, may I verify the records, my lord, if your lordship permits me, my lord.
Yes.
Huh?
Return it.
My lord, any date, my lord, before or after 12th May, my lord? 14th of May? Deeply oppressed.
Please, the lordship. I'm sorry, madam, one matter I could not appear when the matter was called. Item number 30 of supplementary list. Now it is, I'm told that matter is fixed on 7/5, I think. So only thing is that my non-appears is there on that. That may be
30.
Observe 30 of supply.
None appears to cut it.
Much.
27.
Please, lordship. The matter relates to a dispute between the husband and wife over the share of maintenance. The wife demanded maintenance, and there have been two orders, one by a court granting maintenance under Domestic Violence Act, and the another order which is under challenge here. The claim of the petitioner has been that he is on a daily basis earning in a pharmacy, and that is a sum of 400 rupees per month. 400 rupees per day, which in total comes to a figure of 12,000. The wife claimed that the husband's earning will be around 1,50,000 per month. Both are oral evidence. No documentary evidence were produced. The court makes an assessment that the monthly income would not be less than 75,000. Now, this assessment is the subject matter of dispute in the present proceeding.
Any affidavit of assets and liabilities?
The affidavits were exchanged, but I don't think that was in terms of the order of the Honorable Supreme Court. The Honorable Supreme Court laid down a format in which it had to be filed, but it was not done. Although the order sheet records that there was affidavit of assets and liabilities. Your Lordship may kindly see page 79, but I don't think that it was in the format. Page 79, last paragraph, Your Lordships may see in the affidavit of assets and liabilities. In the affidavit of assets and liability, the second party stated that he requires rupees 5,000 as expenses for his son from his second wife. Again, a person having a nominal income of rupees 400 with dependent parents hardly afford a second marriage. So this income of rupees 400 was per day basis. The second party apparently in his affidavit of assets and liabilities concealed the facts of his income by not producing bank statements. As required by law, an adverse presumption may be drawn against him. During hearing, it has been brought on record that the second party that this first party has been awarded maintenance of rupees 4,000 per month for herself and her minor child in the proceeding under DV Act. This court taken cognizance of the said award, but nothing prevents this court from awarding monthly maintenance to the first party and her minor child under the this proceeding, if the amount so awarded is not adequate, and considering the income of the second party as claimed and stated by the first party and her witnesses, the first party and her son entitled to much higher amount of maintenance. At the same time, the court is also aware that neither party fully adduced evidence of the income of the second party, and there appears huge difference of claims as to income of the second party by the first party and the testimony of the second party as to his own income. But as the burden was on the second party and he had withdrawn the best evidence and also concealed facts in his affidavit of assets and liabilities, I am of the view that half the amount claimed by the first party as income of the second party can well be presumed to be the current income of the second party per month. Considering the income of the second party is around 70. Now, on the basis of an assumption, the court makes out that the second party's monthly income will be around 75,000 because the first party in her evidence has stated that it will be 1,50,000 per month. Now, the subject matter is that the petitioner, before your lordship, he is employed in a pharmacy and that is in a rural setting. And in a rural setting, I say that I am employed under the owner on a daily basis payment of 400 rupees. The second party says, the respondent says that I in fact own the pharmacy. Now, whether I own the pharmacy or not, except for their oral testimony, nothing has been brought on record. And my evidence states that I remain there as a workman under the employer on a daily basis payment of 400 rupees. Now, to presume that even if I own the pharmacy, to presume that I generate a revenue of 1,50,000 per month from the business of pharmacy, that will be something far-fetched.
What has the court held? What is to be your income?
My income, I said that it will be around 12,000 rupees per month.
No, no, according to the code below.
Code below has assessed it at 75,000. Because the wife states in her evidence that my income is around 1,50,000 from the business of pharmacy. So court presumes that at least it will be 75,000. 50%. Basically, I have twofold submissions. First of all, this assessment by the court below that my earning is 75,000 rupees per month. My disposable earning is 75,000 per month. That is not correct. It is absolutely based on assumption. And secondly, even if this is assumed to be having some basis, then also the trial court ought to have deducted the amount of rupees 4,000, which I have been paying under the orders of the DV Act. That has not been done. So it requires some modification.
Fit of assets and liabilities are there from by both sides.
Yes, that's why I said, Millard, in paragraph page 79, there is a reflection. But perhaps, Millard, my understanding is that this is not in terms of what the Honorable Supreme Court had laid down. The affidavits ought to have been more pointed on the details. It is a sort of a vague statement. Now, from the petitioner's side, from the wife's side, her oral testimony is that I own a pharmacy and therefore I generate a monthly earning of rupees 1,50,000 per month, around rupees 1,50,000 per month. Now that to make it as a basis for some assessment that I would be earning at least 75,000 a month, that will not be proper.
No, I think it is in proper form.
No, as the trial court has
As per
also.
both are same. As per this is the affidavit submitted.
No, as the trial court has said that there are elements of concealment. That's why I am making this submission.
Who is MA pass? You or her? You said qualification, educational, professional qualification of other pass. Other spouse, MA pass. You are.
My lord, but I am a, my lord, the housewife and I have a child, my lord. Now, I have been abandoned, my lord, totally in abandoned condition, my lord. Well, my lord, after the order of the learned trial court below, even after the order of my lord passed by this honorable court, my lord, no payment has been coming, my lord, regular payment.
Well, my instructions are otherwise. My friend has been saying that all along.
Yes.
But my instructions are otherwise. That is not correct.
No, if he's paying, my lord, he can brought the payment on record also here, my lord. If he's paying, my lord.
Yes.
So that is, in a nutshell, that is the case. My case is that my earning is
So
400
basically, everything is oral evidence.
everything is oral evidence. I say that my earning is 12,000 a month. She says that my earning is 1,50,000 a month. Now, trial court has awarded 20,000 per month as maintenance, assuming that my earning would be 75,000. And that too, without deducting the money that I have been paying under orders, under the DV Act. 4,000 rupees I have been paying under DV Act. So whatever amount the trial court would otherwise find appropriate, the trial court ought to have deducted the amount that I have been already paying. That is one limb of submission. The second submission is that this assumption of 75,000 is without any basis. He has stated in her evidence that I own a pharmacy, but nothing has been brought on record. Huh?
Have you rebutted that in cross-examination?
Well, your lordships will kindly see the cross, that is at page 24. Our evidence starts at page 21. Page 21. 21. Now, in page 21, it starts in paragraph 6 at page 22, she says that the opposite party is a businessman who deals in medicine and he has a Pakka Assam type house on 5 bighas of land. From all sources, he earns at least a sum of 1,50,000 per month. This is the statement. And as against it, as against that, my statement, your lordships will find at page 35, paragraph 8. এটা বরাবর দিয়েছে।
More interesting.
What is the reasoning of the court below to come to the finding of 75,000?
Well, that reasoning, your lordships will kindly come again to page 80. It is only that since there is a higher money claimed by the other party, so it will be, average will be taken. Paragraph, third paragraph, page 80, third paragraph. At the same time, the court is also aware that neither party fully adduced evidence of income of so and so, so and so. Then there appears huge difference of claims as to income of the second party by the first party and the testimony of the second party as to his own income. But as the burden was on the second party and he had withdrawn the best evidence, this is the reasoning given, and also concealed facts in his affidavit of assets and liabilities, I am of the view that half of the amount claimed by the first party as income of the second party can well be presumed to be the current income of the second party. Considering the income of the second party is around 75,000 per month. Now, these findings that I have withdrawn facts in the affidavit, that is also that there is also no discussion as to how and why it is held so. Just one judgment, don't you?
So yes, respondent.
May I please, as your lordship? My lord, if we go by this criminal revision petition, my lord, in the grounds, they have said that, my lord, we have or the matter of the domestic violence case, my lord, which has been decided and the rupees 4,000 had been granted also by the, my lord, learned trial court below had not been brought on record. But, my lord, the impugned judgment which they have challenged, my lord, it very much reflects in page 80. My lord, the paragraph starts from the during, my lord, just for a moment, I am bringing my lordship's attention to that ground first, my lord, page 80. During hearing, it has been brought on record by the second party that the first party has been awarded maintenance of rupees 4,000 per month for herself and her minor child in proceeding under the DB Act. So, my lord, it was very much under consideration before the learned trial court below that there is already a maintenance of rupees 4,000 had already been granted. So, there is no concealment of facts, my lord, that it was not known to the learned trial court below that the before passing of the judgment, my lord, it has not been considered. So, my lord, and thereafter, if my lord, if we come to the below paragraph, my lord, at the same time, the court is also aware that neither party full adduced evidence of the income of the second party, and there appears huge difference of claims as to the income of the second party and by the first party, and the testimony of the second party as to his own income. But as the burden was on the second party and he had withdrawn the best evidence and also concealed the facts in his affidavit of assets and liabilities, I am of the view that the half of the amount claimed by the first party as income of the second party can well be presumed to be the current income of the second party per month. Now, my lord, here is a case, my lord, where I as a wife, my lord, I have maintained a very tried to maintain a very good, healthy conjugal relationship with my husband, along with my child, my lord. From the very inception, my lord, from the date of my marriage, my lord, I had been objected to the severe physical as well as, my lord, mental harassment, my lord, demand of dowry was also there, which I could not fulfill, my lord. Those things were also, my lord, no separate case had been lodged. Now, my lord, here is a case wherein, my lord, the income, the issue of income, my lord, I being the wife, my lord, I am the best person to know, my lord, that what the nature of business my husband is doing or how much income he is, my lord, carrying in every month, my lord, I am the best person to. But, my lord, unfortunately, I do not have any access to the records of my husband regarding license or any kind of those bank statement or document which I have been never given the access. So, therefore, my lord, admittedly, my lord, if my lordship is going to interfere with the judgment also, admittedly, my lord, I could not bring those things on record before the learned trial court below. But, my lord, the issue is that the affidavit which has been filed by the, my lord, the husband, and if we go by the cross-examination, my lord, there is no any such specific denial of the husband also that he has not been not earning the said amount of rupees 1,50,000 or something like that, my lord. So, therefore, my lord,
There is suggestion is there, it is not a fact.
my lord, it is not a fact that suggestion is there, but, my lord, it has not been it is not such a case, my lord, that he has denied, but the suggestion is there. If so, therefore, my lord, the issue of the
Denial, what else?
my lord, it is there, my lord. Lord, I do not have a very good knowledge regarding these issues, my lord. So, therefore, my lord, we can say that arriving at the decision of the learned trial court below, my lord, by this judgment, my lord, is nothing to interfere. And secondly, my lord, the issue of maintenance is my learned respected senior friend is saying that it has been paid to me. It has not been as a whole 20,000 had been paid to me, my lord. I have a minor child that requires a maintenance, schooling.
That is a different process.
No, my lord, the process
It
is
is
that.
not paid, you have to apply there.
No, my lord, I have to apply there because, my lord, in the petition which I have lodged before the, my lord, learned trial court below regarding this maintenance, my lord, it includes the both, my lord. It includes the both, the wife as well as the child issue was also there, my lord.
All right, if that is not been paid to you, then remedy is different.
No,
We
it
need.
has been paid, my lord. What the learned trial court below has done, out of 20,000, 12,000 has been directed to be paid to the wife and 8,000 for the child, my lord. Now, when this honorable court, my lord, take up this petition, my lord, the 12,000 had been stayed and directed that remaining 8,000 is there is no interference of this honorable court that it has directed to be paid. Even then, my lord, this 8,000, my lord, my instruction is that has not been paid regularly till date, my lord.
That is what I am saying, that remedy lies there.
No, remedy lies there, my lord, but the issue of, my lord, this 20,000 payment is very negligible and very limited at this moment, my lord. So, therefore, my lord, there is no scope of, my lord, if this order is, my lord, is interfered with, my lord, then, my lord, it will be very difficult for me to survive, my lord, at this moment, my lord, because I am fully dependent. I do not have any other source of income, my lord. So, I have been, my lord, totally thrown out from my house, my lord. Now, just I am taking shelter at my my lord, own parental house, my lord, my father's house, my lord. That's the issue, my lord. And second ground, my lord, which they have taken that the assets and liabilities has not been disclosed also, my lord, but this paragraph, my lord, and the record has also been called for from the learned trial court below also, my lord, that whether that affidavit is a part of the record or not, my lord, that
It is.
my lord. So therefore, my lord, if anything is not there, my lord, then the law is well settled, my lord, and the such affidavit is there. So, my lord, there is no scope for again submitting the assets and liabilities there, my lord. Will not serve any purpose, my lord. And my lord, this petition, they are enjoying the interim, my lord, from 2024, my lord. So therefore, my lord, at this moment, my lord, I am very difficult for me to, my lord, passing my day-to-day affairs, my lord.
All right, that is all.
My lord.
Only one thing, if I can point out, I would be relying on this one paragraph from Rajesh versus, Rajnish versus Neha. Para 128, I'll pass on the judgment.
It is already here.
Yes. Para 128 is regarding the setup. Yes. Obliged.
CB.
My lord, since reserve the judgment, my lord, obliged.
On timing item 31.
May it please your lordship. 482 anticipatory bail application. The FIR is at page number 14 here. Page number 14 is the FIR. May I go through the FIR, your lordship?
CD.
May I read the FIR, your lordship? Page number 14.
Yes.
Sir, with due respect, I would like to inform you that on 15th of March 2026, Sunday, from Shri Agro Food Products LLP, a truck is loaded with peas. Truck number so. The truck was loaded with 500 bags of peas at Adara Railway Yard. This truck was to be driven by above mentioned accused, that is the driver of the vehicle, from Rani Railway Point to Imphal, Manipur. And the accused person, as per our last contacted with him on 16/3/2026, Monday, had reached Nagaon. Thereafter, after that, we were unable to contact with the accused. The accused had switched off his mobile phone. Instantly, on our inquiry of the vehicle owner, he informed us that he is unaware regarding the whereabouts of the driver and vehicle, and we were suspicious about that the accused, along with other accomplices, has stolen the vehicle with 500 bags of peas and sold them unknown places. Along with the FIR, the accused and the vehicle owner details have been given. So kindly investigate the above mentioned incident and take necessary action against the accused and the vehicle owner. My lordship, the case at large is that the person who has loaded the goods in the truck, which is 500 bags of peas, is saying that the vehicle owner, when he contacted, could not trace the driver. May I please draw the attention of your lordship to paragraph number 9, page number 5, your lordship. One of our amendments where we have mentioned, your lordship, that when the truck was loaded, which is also a part of the forwarding report when the owner of the truck was arrested, your lordship. In paragraph number 9, page number 5, that the accused petitioner begs to state that on 15/3/2026, after loading of the goods from Azara Railway Yard, the petitioner proceeded towards Imphal strictly as per the instruction of the vehicle owner and was accompanied by the brother-in-law of the vehicle owner, your lordship. Therefore, the owner of the truck saying that he could not trace us is totally a misrepresentation, because his own brother-in-law was with us, that is the driver. I am the petitioner, I am the driver of the truck, your lordship. And after I have repeatedly informed the truck owner when reaching Nagaon on the way to Imphal that his truck has some difficulties and it needs to be corrected, he asked me to hand over the truck to another driver and allowed me to go home, because on 21 there was Eid, your lordship, the festival of Eid, and this happened on 17th and 18th, your lordship. Thereafter, as per the instruction of the owner of the truck, I handed over the keys to the new driver, which I have mentioned in paragraph number 7 as an averment, and I have left for Eid with my family, your lordship. Thereafter, the new driver, the owner of the car, and his brother-in-law, your lordship, are aware about the whereabouts of the truck, your lordship. The owner of the truck has already been arrested. I am ready to cooperate and participate in the investigation and inform everything to the police. All my communication with the driver and all my communication with the owner of the truck, may I kindly be protected, your lordship. There is nothing which I was in command of, your lordship. I was simply the driver of the truck, your lordship.
Whom did the goods belong to?
The goods belong to the informant, your lordship. That's an agro-based. It's Karamoni Mohanto. He is the
in charge of an agro farm, your lordship. This is the agro farm, Sri Agro Food Products LLP, from railway yard in Rongia, and it was to be transported, Azara, it was to be transported to railway yard, Imphal, your lordship. Peace.
Now, who has been arrested?
The driver or the owner of the truck has been arrested, your lordship. The owner of the truck has been
And
arrested.
the second driver?
And second driver is not yet arrested, your lordship. That is who is the brother-in-law of the owner, your lordship. And therefore, the owner saying that he cannot communicate with me when his own brother-in-law is in the truck is completely false, your lordship. Moreover, your lordship, kindly come to page number 21, your lordship. And this is in the grounds of arrest of the owner of the truck. In paragraph number 1, it is clearly mentioned that paragraph number 2, your lordship, on 15/3/2026, Aslamuddin, he is the owner of the truck, he has been arrested, along with other accused person, proceeded to Azara railway station with a white Baleno car bearing registration number this and conspired the entire crime, which means the owner of the truck was at the place when the truck was being loaded. His brother-in-law entered the truck. I am just the driver to transport it to Imphal, your lordship. And it is entirely his monitor, his supervision, his command, your lordship. I am just an employee, your lordship. May I be protected, your lordship?
Yes,
From the CD, it can be ascertained that, however, from the statement of my learned friend lordship, it has been came to be known that all the persons are there. That person, that Aslum Uddin lordship, who is actually the caretaker of it is in the name of his uncle lordship. But he expired and he is taking care of this person. And from the statements of the various witnesses are also there, he is also present at the point of at the time where these things has happened, lordship, loaded the piece in the truck, lordship. He is also present.
Cool.
This person, lordship, Aslum, the caretaker of the truck, he is also present. This person is also present, the driver, and it has been seen that, lordship, at the point where it was loaded, lordship, he was driving the vehicle in the middle, lordship. And moreover, his statement is also there. Aslamuddin, the caretaker, he also stated that it was sold in a Silchar, lordship. And accordingly, the police has seized, though not all, lordship, seized only 100 grams of this piece in Silchar, lordship. This piece, lordship.
100 grams.
Others in the scattered position, approximately 100 grams of yellow, it is stated here, Lord. Others have been sold, may have been
Where
sold.
is it from? Chanawala?
No, Lordship, it is a go down. In a go down in Silchar, Lord, in Silchar. And in that place, Lordship, one CCTV footage is also there. In some place, Lordship, is there from where this CCTV footage has been there. And in that go down, Lordship, one vehicle was seen, Lordship, from where unloaded the piece. It has been there. It is in the seizure list also, Lordship. So it can be stated that, Lordship, in the middle, this person has, they have linked, they have communication also, Lordship, with this person. They cannot state it that only this. All of them are involved in this case. And invoice is also there from where this person, Lordship, the complainant has also provided invoice of the bills of this piece, Lordship. So it is there. It is proved. And it is also there, Lordship, they have to send it to the Mizoram or Manipur. I apologize, Manipur. But in the middle, they sold this piece, Lordship. So materials are there.
Your lordship, moreover, your lordship, just one more submission, your lordship. I would have been directly implicated if the truck would have disappeared, but the truck has already been recovered and it is lying near cement factory at Bodorpur, which is a part of the forwarding report, your lordship. My only contention is that I am not in a commanding position. I cannot take the goods away, 500 bags of peas, your lordship. I am just a simple driver. And on 21st, the date on which the affair was registered, I was celebrating Eid with my family, your lordship. Same exact date of the festival, your lordship. May I be protected so that I can submit all
Another person is also there, Lordship, some Sikh. He is a handyman of this vehicle. He was not able to apprehend it. Police has not been able to apprehend it.
of the owner, brother-in-law of the owner. Your Lordship.
Okay, Lordship.
These kind of incidents are becoming more common every day. We are getting more and more cases like this.
Your Lordship, I'm ready to submit all my communication through my phone, which I had the owner and informed him that your truck has faced a difficulty, there is mechanical issues. Everything I'm ready to submit to the IO.
Yes, in every case, that is the story. In one case, all the 4 tires got burst together. Send over the CD. Number